Here's the hard truth. Not every new invention is patentable. Even if you think it's new, the Patent Office may reject it as being too obvious. But what does that actually mean? In this video, I'll explain exactly what makes an invention too obvious to patent and what you can do about it. Obviousness is one of the top reasons that the Patent Office rejects patent applications. It doesn't mean your invention is invaluable. It just means that even though your invention may be technically unique, that no one has done exactly the same thing, the examiner at the Patent Office thinks that someone with ordinary skill in the field of your invention could have easily figured it out. Let's break down how this works. The Patent Office asks, if you combine what's already known, would it be obvious to someone skilled in this area? If the answer is yes, then your invention doesn't qualify. As an example, adding a cup holder to a folding chair when there have been other cup holders in chairs, just not in folding chairs, that's obvious. But if you create a new mechanism for a cup holder that allows that cup holder to fold up as the chair is being folded, that's probably not obvious and would likely be patentable. Here's some common examples of too obvious ideas. Inventions are often rejected as obvious if they are simple design tweaks, like changing the size, color, or material, combining two features that already exist in the same general field, swapping one common material for another, or using a newly available technology in an expected way. For example, when a new battery technology comes available that can store more electricity in the battery, in other words, make it last longer, but then you say, no one has used this technology before to extend the battery life of a cell phone. Now, this would be an expected use of that technology, and therefore the idea of just using this type of battery in a cell phone would not be patentable. If it feels like the next logical step, the Patent Office will likely call it obvious. How the Patent Office determines obviousness. Examiners don't guess. They use prior art to establish a baseline for what's already known. Then they'll use the prior art to compare to your invention to see how it's different from what's already known. But mostly what they'll be looking at are existing patents. If they find two or more patents in the same field that when combined would amount to your invention, they may consider it to be obvious. It's like solving a puzzle with pieces that already exist. If your invention is just a predictable combination of those puzzle pieces, it won't qualify. Strategies to overcome obviousness. The good news, an obviousness rejection doesn't need to be the end. You can fight back against a rejection by showing unexpected results. Your invention achieves something surprising. For example, let's say you have a supplement formulation. You add an ingredient that's known for improving blood circulation, but unexpectedly, it also promotes weight loss. That unexpected result can be proof that your invention is non-obvious. Technical challenges solved. It works when others have failed. For example, yours works where others have failed. Remember the new battery technology in the cell phone example? Maybe there's a practical reason why that battery technology can't be used in a cell phone, but you find a technological solution that makes it possible. That may be patentable. Industry recognition. Experts didn't think it was possible until you did it. Maybe people in the field have looked for a solution for decades, and the answer might have been right under their nose. But the fact that they'd been trying so hard and no one ever discovered this combination until you did it might mean the invention is not obvious. Careful claim drafting. You want to focus on what's truly new and innovative. Ultimately, it's the claims in your patent application that get reviewed and may be rejected for obviousness. After a rejection, refocusing your claims on the non-obvious part of the invention is the key to overcoming the rejection. Many patents start out with an initial obviousness rejection, but then win approval with the right strategy. Bonus tip. Here's something most inventors don't know. Even if your invention is obvious today, you might still get protection in some way through a design patent or through trademarks. A unique look, shape, or brand identity can sometimes protect your invention just as powerfully as a utility patent. Don't overlook these tools as a way to protect your invention, protect your product as best as possible. I'd love to hear from you. Do you worry that your invention may be too obvious? Drop your thoughts or questions in the comments below. I reply to as many as I can, and your question may inspire my next video. Remember not to include any details or any proprietary confidential information in your comment. Don't let your invention get dismissed as too obvious. If you want to know if your idea qualifies, what can be done to make it qualify, or what else can be done to protect it, click the link below and schedule your free strategy call with me. Let's make sure your invention gets the protection it deserves. And if you found this helpful, the next video you should watch, I answer the top 10 provisional patent questions that people ask. You'll learn how provisional patent applications work, the deadlines, and the biggest misconceptions. Click here and I'll see you in the next video.